Begin, everyone. Thank you so much for coming. Many of you know me. If for those of you who don't, my name is Tim Armstrong. I'm a member of the faculty here at the College of Law and also serve as the Associate Dean of Faculty and Research. On behalf of Dean Hammoudi and the College of Law Faculty and Administration, I'm very pleased to welcome you to the 2025 Distinguished Visiting Professor here at the University of Cincinnati College of Law. Dean Hammoudi really wanted to be here himself to welcome you, but we put him to work this week teaching a short course that is meeting right now down the hall. So he sends his regrets, but that gives me the very happy task of introducing today's esteemed speaker. The Distinguished Visiting Professor of Law was endowed in 2006 by Stanley Chesley, a graduate of the College of Law, and Judge Susan DeLotte, to bring outstanding legal scholars of national and international prominence in all areas of law to the college. We're very grateful for their support. Our lecturer this year is Paul Finkelman. Professor Finkelman is a historian and constitutional law scholar. He received his BA from Syracuse University and his MA and PhD in U.S. history from the University of Chicago. He was later a fellow in law and humanities at Harvard Law School. Professor Finkelman has held endowed chairs at the University of Miami History Department, the law schools of Duke, LSU, Marquette, the University of Tulsa College of Law, and most recently at Albany Law School, where he is currently Distinguished Professor of Law Emeritus. From 2017 to 2022, he was president and chancellor of Gratz College in the greater Philadelphia area. He also has teaching experience outside the United States. Professor Finkelman held the Fulbright Research Chair in Human Rights and Social Justice at the University of Ottawa and held an endowed chair as a visiting professor of human rights at the University of Saskatchewan. Professor Finkelman is a prolific and highly influential scholar. He is the author or editor of more than 50 books. His most recent major book was Supreme Injustice: Slavery in the Nation's Highest Court, published in 2018 by Harvard University Press, which examined how the 19th century Supreme Court dealt with the issue of slavery. His book, Slavery and the Founders: Race and Liberty in the Age of Jefferson, now in its third edition, examined how slavery affected the writing of the U.S. Constitution and the politics of the early national period. He has also written over 200 scholarly articles, including an essay on Justice John Mclean published just last year in the Journal of Supreme Court History. The Supreme Court of the United States has cited Professor Finkelman's work 6 times in cases involving religious liberty, affirmative action, and the Bill of Rights. The late Justice Ruth Bader Ginsburg quoted Professor Finkelman on the meaning of the 14th Amendment in her 2019 opinion for a unanimous court in Timms versus Indiana. He has also been cited and quoted by many other state and federal courts. In addition to his very long record of scholarship on slavery and American constitutional law, Professor Finkelman is also an expert on civil and religious liberty, African American and American Jewish history, and legal issues surrounding the game of baseball. He was the chief expert witness in the litigation successfully challenging the installation of the Ten Commandments monument in the Alabama Judicial Building, as well as a lawsuit over who owned the 73rd home run ball hit by renowned slugger Barry Bonds during the 2001 MLB season. I hope you will join me in welcoming Professor Finkelman to UC.
It's on. Good. First, I want to thank the law school for bringing me here. Dean Hammoudi, who can't be here right this moment. As a former college president, I fully understand that when you're running an institution, no matter what you plan, something always intervenes. And so I hope he will show up later. It's delightful also to be in Cincinnati. I've done a lot of research in Cincinnati. I have been here many times. I was a consultant for the National Freedom Center and Underground Railroad Museum. And I really like Cincinnati. And I think it's one of the unknown jewels of the United States. Of course, in antebellum America, Cincinnati was well known. It was the Queen City of the West. You may also know or not know that it was also known as Porkopolis because it was the leading center for packing and shipping, mostly to the south, the large hogs raised in Ohio and then put in barrels and sent for other people to eat. So it's got a great and important history. It also became the home of the first Ohioan to serve on the Supreme Court, John Mclean. And I want to talk about Mclean today in the context of American slavery. In 2002, the Washington Post published a breathtaking article on all of the members of Congress who had ever owned slaves. The Post found more than 1,700 congressmen had, at one point or another, owned enslaved Black people. And the Post said this is who they were and this is how they affected the nation. The article did not surprise people who understand the nature of American history or American slavery. Slavery was legal in every one of the 13 states in 1775 when the Revolution began. By the time the first Congress under the Constitution meets, slavery is still legal in every state except Massachusetts and New Hampshire, and it will remain, of course, legal throughout the United States until 1865, when the 13th Amendment ends it. Needless to say, in the southern states, which grow from a handful in 1775 to 15 by 1860, virtually every member of Congress is a slave owner. This should not surprise us. Some of them were small-time slave owners, like David Crockett, better known as Davy Crockett. Sam Houston, Andrew Johnson owned a few slaves. Other members of Congress, such as James Monroe, James Madison, Charles Pinckney, Charles Carroll of Carrollton, who signed the Declaration of Independence, Daniel Carroll, Henry Lighthorse Harry Lee, John C. Calhoun, Howell Cobb, Judah P. Benjamin, Alexander Stephens, and Jefferson Davis, who will become the president of the Confederacy, were all slave owners. Many went on to be presidents of the United States, or in Davis's case, president of a traitorous would-be nation south of the United States, and many went on to other important positions in government. But it sometimes surprises people that representatives and senators from the North were also slave owners. These include William Samuel Johnson of Connecticut, a signer of the Constitution, Aaron Burr, a future vice president, DeWitt Clinton, a governor of New York and later a member of Congress, Martin Van Buren, a future president from New York, the New Jersey delegates to the Continental Congress, including Abraham Clark, who signs the Declaration of Independence, Jonathan Dayton, who signs the Constitution, William Patterson, who signs the Constitution and then serves on the Supreme Court, Robert Morris of Pennsylvania, George Clymer of Pennsylvania, and both signers of the Constitution, and Ohio's first president, William Henry Harrison, who of course was raised in Virginia and owned slaves when he came to Ohio early in the 19th century. And while the territorial governor worked to have the Northwest Ordinance modified so people could bring slavery into Ohio, fortunately, he failed in this process. James Buchanan, a U.S. senator and congressman from Pennsylvania, grew up in a slaveholding family, and had the Post included members of the Continental Congress, we would add a whole list of other people who served in Congress. Thomas Jefferson, Patrick Henry, John Rutledge, Arthur Middleton, Thomas Lynch from the South, Benjamin Franklin, John Hancock from the North, all at one time or another owned slaves in their life. Slavery was part of America from day one. And whether you want to deal with that or not, it's something I think that all Americans eventually have to come to terms with. The Constitution is littered with clauses protecting slavery, and some of the very first laws passed in the United States in the 1790s dealt with either protecting slavery or persecuting in one way or another free African Americans. This is part of our history. Perhaps the most surprising thing about the Post's story was the discussion of John Mclean. And the Post almost gleefully, like they're so happy to discover this. They say, history remembers Representative John Mclean, an Ohio congressman and then longtime Supreme Court justice, as one of the two jurists who dissented in the notorious 1857 Dred Scott decision. But then they say, yet Mclean was one of those rare residents of the free state of Ohio who was recorded as a slaveholder in the 1820 census when he was serving on the state Supreme Court. The only problem with this is that Mclean did not own a slave in 1820. And in fact, nobody in Ohio owned a slave in 1820. And the manuscript census records, which still exist, have no category for slave. The census taker would go to your house and they'd check off who's there by age, by gender, by race. So there's a category for free Black people. They'd check a category off if you were Native American. But there is no slave category in the census. So why the Post thought that Mclean owned a slave in Ohio is beyond me. I have great respect for journalists who do journalism by interviewing live people and figuring out what's going on in the country. My thought has always been that when they pretend to be historians, they might actually want to consult with one of us. Obviously, I'm looking for work, right? But they might want to consult with one of us and actually find out how to do something like read a census record. Mclean does not own a slave in 1820. And as I said, the form used to collect the data for Warren County, Ohio, where he lived, does not have a category of slave. It does have a category of free colored persons. By the way, subsequent to this, the Post went into its website and did a mea culpa and said Mclean did not own slaves. But the problem is that the American people will be unlikely to ever see this mea culpa because it's a couple of years later, and that's a problem. But despite the Post's completely inaccurate story about Mclean, it does lead to the question, how does John Mclean relate to slavery, and what does it mean? Certainly his life shows us the ubiquitous way in which slavery seeps in to other people's lives. Any American who travels south of the Ohio River, south of Pennsylvania, west of the Mississippi River, Missouri, Arkansas, Louisiana, Texas. Any American who travels in those 15 slave states, plus the District of Columbia, where slavery is legal until 1862, would encounter slavery and in some ways interact with it. If you went to Charleston on business, you would stay in a hotel, and everybody working in that hotel would probably be an enslaved person. If you got in a carriage, the carriage driver would probably be an enslaved person. It is very hard to escape this institution because it is everywhere. And so that's one of the things that led me to think about John Mclean. So who is John Mclean? He is born in New Jersey in 1785. His father, Fergus Mclean, is a Scotch-Irish Presbyterian who immigrates to New Jersey just before the American Revolution. He serves as a soldier in the Revolutionary War. And following the war, the Mcleans begin to migrate west, as hundreds and hundreds of Americans do, ultimately thousands of Americans will do. They go to Virginia, they go to Kentucky, and they finally end up in what is called the Northwest Territory in Warren County, Ohio. And that is where John Mclean is raised. By the way, that's also where, for the first time in his life, he actually attends a real school. So he's 12 or so before he gets to actually go to a functioning school, in part because Kentucky and Virginia don't have very many functioning schools. They don't have public school systems. One of the other things about that line between slavery and freedom is that public schools exist all over the North, and they are very rare in the South. Public libraries exist in the North. They are very rare in the South. But Mclean gets well educated. He's clearly a very bright young man, and he will rise very quickly in his profession. Northwest Ordinance of 1787 said that there could be neither slavery nor involuntary servitude in the territory north of the Ohio River. And so it seems likely that Fergus Mclean ended up there because he did not want to live in a slave jurisdiction like Virginia or Kentucky that he passes through. And by the way, in that way, there are parallels between John Mclean's life and Abraham Lincoln, who is born in Kentucky, but when he's a young child, his father, Thomas Lincoln, decides he does not want to live in a slave jurisdiction. And so he moves to southern Indiana, where Lincoln is raised. By the way, about 50 miles away from him is young Jefferson Davis, whose father decides they love slavery, and they move to Mississippi, where he becomes a major slave owner. I should add, by the way, a couple of people asked me about my tie. These are pictures of the people who ended slavery in the United States. Many of them are, of course, some of the great sons of Ohio. Ulysses S. Grant, General Sherman, General Sheridan, General Custer, and a number of other people who are the people who bring the Emancipation Proclamation to the South. Just as an aside, if you are, late at night and you can't find anything to watch on TV, and you stumble on Gone with the Wind, and you see this, crying about the destruction of General William Tecumseh Sherman's army marching from Vicksburg, Mississippi, all the way to Charleston and then up the coast into North Carolina. You should imagine that in front of Sherman's army are a couple of angels or cherubim carrying a sign which says, "All people who come behind this sign are free forever." And you should understand that Sherman's March to the Sea, as it's called, is the greatest liberation of human beings in the history of the world until the Allies' march on Berlin in 1944, 1945. And that's an important thing to understand also about the United States. So the territory says there can be no slavery in the area. The problem is that in parts of the Old Northwest, particularly southern Indiana and southern Illinois, there were already thousands of people who were being held in slavery. These are people who had lived in the Northwest when it was part of France, because all of this area was French until the end of the 7 Years' War. For those of you who are old enough, and when you were in school, it was called the French and Indian War. And when that war ends, all of this gets ceded to Britain. So there are this group of people who are known as the Old French Settlers, and they have slaves. People are always astounded, France and Indiana. And of course, the important thing is, who is the most important person to ever come out of the state of Indiana? And we know it's Larry Bird, right? The basketball player who came from French Lick, Indiana. Lick, of course, is a salt lick. So so there is slavery in the Northwest, but there's none in Ohio. And in 1803, Ohio becomes the first state to enter the Union with no slavery in it and no history of slavery in it. And the Ohio Constitution is emphatically anti-slavery. It says there shall be neither slavery nor involuntary servitude in this state, otherwise than for the punishment of crimes where the party shall be duly convicted, nor shall any male person arriving at the age of 21 or female person arrived at the age of 18 be held to serve any person as a servant under pretense of indenture. Why is this the case? Because they are fearful that people from Kentucky will come with their slaves, but they'll say, oh, they're not slaves, they're indentured servants. They agreed to serve me for 20 years if I would bring them to Ohio. So what the Ohio Constitution is, it allows a 1-year indenture if you come with somebody over the age of male 21 or female 18. And the theory of that is that they're perfectly willing to allow people from Kentucky to bring a slave to Ohio and free that person, but you can't bring them as a lifetime indentured servant. So that's the nature of the Ohio Constitution. And John Mclean will become a member of the Ohio Supreme Court. He moves to Cincinnati and he studies law here. There are no cases involving slavery in Ohio until Mclean is on the court. But in 1807, the Ohio Supreme Court uses the prohibition on slavery to explain why there must be judicial review in Ohio. And it says that an act of the legislature can introduce slavery, but then the court says it's a case having nothing to do with slavery, it has to do with the power of the court. It says if an attempt by law should be made to introduce slavery, courts have not only the power, but the indispensable duty on application according to the due and ordinary course of law to cause right and justice to be administered without denial or delay by striking down the law. So Ohio is emphatically not going to have slavery. In 1804, a year after statehood, 19-year-old Mclean moves to Cincinnati. He becomes a law student, which means since there's no law school here, he clerks for a law school. By the way, when I was at Albany Law School, I was the President William McKinley professor of law at Albany, because in 1866, Major McKinley mustered out of the Union Army and wanted to go to law school. And if you're in Youngstown, Ohio, what's the closest law school? Albany Law School. There are no law schools in Ohio as late as the mid-1860s. So Mclean studies law, and he studies it under a man named Arthur Sinclair Jr., whose father had been the territorial governor of the Old Northwest. Mclean gets married. He marries a woman who lives in Kentucky, but there's no evidence that her family owned slaves in Kentucky. Mclean in 1811 converts to being a Methodist. This is important because the Methodist Church is the most emphatically anti-slavery church of any of the major faiths in the United States at this time. And of course, in the 1840s, the Methodist Church will divide. It'll be the first national church to divide between the Southern Methodists and the Northern Methodists over slavery. Mclean will be a devout Methodist for the rest of his life, and that reaffirms his position as being devoutly opposed to slavery. In 1816, in 1812, he is elected to Congress. In 1814, he is reelected to Congress. He then resigns from Congress in 1815 because he is appointed to the Ohio Supreme Court. He's a very young guy to be appointed to the Ohio Supreme Court at this time, but everybody understands he's very smart and very talented. And on the frontier, which Ohio clearly is, smart and talented people can rise very quickly because they're needed. He goes to the Ohio Supreme Court, and he hears early on a case involving slavery. It's a case called Ohio versus Carneal. It is an unreported case. So if you go into the Ohio Supreme Court reports, you never find the case. It is published in an obscure book that publishes the unreported cases of Ohio. But in this case, which involves a Kentucky slave owner who inherits a slave and brings him to, actually involves a man living in Cincinnati was from Kentucky, and he inherits a slave from his father, brings the slave to Cincinnati, and Mclean rules emphatically that if you bring your slave to Ohio, the slave becomes free. And so in 1817, Mclean is on record as opposing slavery and writing the decision that says, bring a slave to Ohio only if you want to free them. In 1822, he leaves the court and accepts a position as the commissioner of the General Land Office in Washington, D.C. He gets a salary of $3,000 a year, which is 3 times as much as he made as a Ohio Supreme Court justice. Mclean is never a wealthy man. He's a public servant most of his life. He is a Supreme Court justice in an age when Supreme Court justices don't have extremely wealthy friends sending them around the world on private jets, or in other ways buying them $150,000 RVs to drive around the country. So Mclean is relatively modest, lives a very modest life. He grabs the $3,000 salary. He's happy with it. However, shortly after getting there, President James Monroe in 1823 asks him if he would like to be Postmaster General. It's a better job. He takes it. Now, he's expecting to leave Washington in 1824 when Monroe's term ends. There's no reason to believe he'll be continued on as Postmaster General. So he rents a house in Washington. He lives in the rental house. And then John Adams is elected president, and he asks Mclean to stay on as Postmaster General. And then when Andrew Jackson is elected in 1828, Jackson asked him to stay on as a Postmaster General. He is the only Postmaster General in American history to serve in 3 different administrations and for presidents of different parties. Why did they keep him? Because he is clearly the most competent Postmaster General who had ever served. He cleans up the post office, which is rife with corruption because there was no way of auditing how much money a local post office was taking in. There are not stamps yet. Postmasters rather would take a letter and stamp, 5 cents on it and take 5 cents from the person who's giving it. But whether that ends up in the post office till or the local postmaster's pocket is never entirely clear. Mclean cleans this up, and he really gets the post office working correctly. By the way, John Adams, who hates Mclean, even though he serves in his administration, admits that he was the most competent Postmaster General in the history of the United States. John Quincy Adams. Why does Quincy Adams hate Mclean? Because when Quincy Adams runs for re-election in 1828, Mclean does not use the post office to help him get elected. The idea was that the Postmaster General has a person in every town in America, right? And what Adams expected Mclean to do was to write to every local postmaster saying, you got to campaign for Adams or I'll fire you. Mclean won't do that. So that's his history as Postmaster General. While he is in Washington, he brings his family here. He brings his family to Washington. He rents a house. And in those days, if you rented a house, especially if you're a high government official, it came with servants. Think of running a upper middle class house with no electricity, no indoor plumbing, no running water, no refrigeration. Everything is manual labor. Everything is labor. As late as 1900, the second largest job category in the United States will be domestic servant. It's a world of people who either hire servants or are servants. So Mclean rents a house that comes with servants. But of course, these servants in Washington, D.C. are almost certainly slaves, either owned by the person who's renting the house or hired by the person who's renting the house from some other slave owner. Mclean, as we know now, already hates slavery. He has decided he hated slavery before he got to Washington, and now he truly despises it because he sees slavery in action. He sees it close up. He interacts with the servants in his house, who he doesn't treat as slaves. He treats them as free people, even though they are slaves. And of course, what he learns from them is the great trauma of being a slave comes when your owner decides to sell you, when an enslaved person is sold away from family members, or when a family member is sold away from an enslaved person. And while he is in Washington as Postmaster General, he will ultimately acquire a slave family. It is not clear if he buys the slave family as slaves or simply pays the owner of the slave family a lot of money to go away with these people. Because when he moves back to Ohio after his postmaster generalship, he takes this family with him. And of course, Mclean knows that the minute they set foot in Ohio, they're free. Why does he know it? Because he wrote the decision on the Ohio Supreme Court. So Mclean is technically a slave owner, possibly in Washington, D.C., for a couple of years. But he's a slave owner for the purpose of actually freeing people from their bondage rather than seeing them as a profit source, seeing them as a way to make money. And late in his life, in the 1850s, he will hear from this former slave who is now sick and old and whose wife has died and he's destitute. And he writes Mclean a letter saying, "I'm sorry to bother you, but I don't have anybody else to turn to." When he takes the family to Ohio, he buys them furniture and he finds a house for them to live in. So he sets them up as freedom. So rather than the Washington Post condemning John Mclean as a slave owner, the Post might have written that he is an emancipator because he is bringing slaves out of Washington into Ohio to be free. Now, it's not entirely clear what the actual legality of this is. Everything I have found suggests that Mclean does not actually buy these people as slaves. That is to say, he does not negotiate with the owner for purchasing a slave, and the owner does not actually does not actually record a deed of sale of an enslaved person. It looks like what Mclean does is go to the person who owns the slave and says, if you will manumit this person, which is the legal process of freeing a slave, I will give you what you could get on the open market for this person. So what Mclean really does is acquire people who have been manumitted because Mclean paid for their freedom. Now, hardcore abolitionists don't believe in doing this. Eventually, Mclean will be condemned by hardcore abolitionists because you shouldn't pay somebody to be free. You shouldn't pay for somebody's freedom because that's supporting the slave system. By the way, when the great abolitionist Frederick Douglass runs away to England for a year and a half, He is able to come back to the United States because two abolitionist women in England buy his freedom from the family that owns him in Maryland. And when he comes back to the United States, there are some abolitionists who condemn him for allowing himself to be bought, because that is, from their perspective, supporting the system of slavery. Douglas, of course, says, I wasn't bought, I was ransomed. And if I'm ransomed, I have a right to be ransomed. And he would say to these people, how dare you tell me that I don't have a right to be free in any way that I can become free? And that would be in part what Mclean is doing. In 1829, he briefly serves in the Jackson administration as Postmaster General. But Jackson is uncomfortable with Mclean in part because he'd been a Whig and Jackson was a Democrat, and in part because Mclean is clearly anti-slavery, and Jackson is one of the many slave-owning presidents. He has a plantation in Tennessee. He owns lots of slaves. And so Jackson has to figure out what to do with Mclean. And the easiest thing is to put him on the Supreme Court. That's how you can get rid of political people that you can't fire them, but just put them on the court, because who cares? Nobody cares about the court in those days, right? And so he becomes the first Ohio Supreme Court justice. There will be a string of Ohio Supreme Court justices after Mclean. Mclean dies in 1861, and one of Lincoln's first nominees is Noah Swain of Ohio, whose son, by the way, is a general in the Army, Wager Swain. There will later be a second Ohioan on the court when Lincoln appoints Salmon P. Chase of Cincinnati to be Chief Justice. And of course, Chase had been an active abolitionist lawyer. His nickname is the Attorney General of Fugitive Slaves. And so there's a great irony, or not irony, but actually a statement about the nature of the changing United States, that Roger Taney, the most openly racist, most openly pro-slavery jurist on the Supreme Court, dies, and he's replaced by a man who spent much of his career fighting slavery, Salmon Chase. There will be another Ohio Supreme Court Chief Justice. Anybody know who the second one is? This is your obscurity test of the day. Pardon? Yeah, Morrison Waite. Everybody's heard of Morrison Waite, right? Well, no, actually not. And then of course there will be Chief Justice Taft, who went to this law school. So Ohio will dominate the court, starting with Mclean, or populate the court starting Mclean, just as Ohio will become, despite what the folks in Virginia like to believe, Ohio will become the mother of presidents, right? Because you will have one Ohioan president after another, from Grant's election to Warren G. Harding's election. Everybody seems to be from Ohio, more or less, okay? So Mclean goes on the court, and in his first term on the court hears a case in which a slave claims to be free because the slave had been brought to Washington, D.C. in violation of a law which says that you can't import slaves into Washington, D.C. And Mclean writes the decision upholding the freedom of this enslaved person. What's significant is Chief Justice John Marshall, who's still Chief Justice, had decided 7 previous cases that are almost identical, and every time he found in favor of the slave owner. Marshall never votes to free a slave. Nor does Marshall. Now, Marshall never writes an opinion to free a slave. Marshall says nothing when slaves get their freedom while he's Chief Justice. But if there's an opportunity to get the court to side with him, Marshall always sides in favor of slavery. Most biographers of John Marshall say that he didn't like slavery, he owned very few slaves, and he is, a man of his times. I wrote a book called Slavery in the Supreme Injustice, Slavery in the Nation's Highest Court. And I wrote about the dozen slaves that all the biographers said he owned. And then I found the other 200 that he owned. And he is buying slaves and selling them his entire life. And that's something that American law professors have to come to terms with. The great Chief Justice was flawed in at least this area. Not simply that he is a man who has servants in his house who are slaves. It's that he's buying plantations and filling them up with people to make him rich. So anyways, Mclean becomes an anti-slavery justice. In case after case involving slavery, Mclean sides with freedom as opposed to slavery. In 1842, the Supreme Court for the first time decides the constitutionality of the Fugitive Slave Law of 1793, and it's an 8-1 decision written by Joseph Story of Massachusetts. It is an overwhelmingly pro-slavery decision. Story says that no state can interfere in the return of a fugitive slave. No state can give due process to a person who is allegedly a fugitive slave, and that slave owners, in fact, can go into the North and seize anyone who they believe is their fugitive slave without any judicial process whatsoever. Mclean dissents from this. And Mclean argues that the free Black people in Ohio will be kidnapped by slave catchers if this kind of jurisprudence takes place. A decade and a half later, in Dred Scott, Mclean will, of course, dissent again, writing a vigorous dissent against Tawney's arguments that Congress has no right to end slavery in the federal territories and that slavery is a national institution. In case after case, Mclean says over and over again, slavery is created by local law, and if there's no local law to create slavery, then people who were held as slaves in one place, if they go to a place where there's no local law, will be free forever. And that is his position. At the same time, and this is what makes him more complicated than we might imagine today, Mclean also understands that the Constitution protects slavery. The Fugitive Slave Clause protects slavery. And in cases where it is quite clear that a person is a fugitive slave, is somebody who escaped slavery, Mclean will uphold that status and remand that person back to the person who claims the slave. In one case, he upholds a huge financial decision against an Ohio abolitionist for rescuing slaves who were being taken back to Kentucky. Mclean says that's the federal law. He's a constitutionalist. He believes in the rule of law. He understands the compromises of the Constitution. But in a couple of other cases where it looks like somebody's a fugitive slave, Mclean determines, well, no, they're not, because they were allowed to come into the North for a short period of time, and thus they became free. So when he can avoid the Fugitive Slave Law, he does. Now, I want to say something briefly about his slave owning, because we're almost out of time and I want to leave some time for questions. So Mclean, as I said earlier, brought a slave family from Washington, D.C. to Ohio, set them up with a house, got them furniture, got them a place to live, and they live on their own, sort of happily ever after, for the next 25 years. until a combination of sickness and poverty has this former slave man going back to Mclean and asking for help. In the 1830s, Mclean's wife is very ill, and Mclean needs to find somebody to take care of his wife. And somebody suggests that there is a teenage slave in Covington, where his wife is from, a young teenage girl who might be willing to take care of his wife. And Mclean, through a convoluted process where he's kind of at arm's length, he uses lawyers and other people to do the negotiations, goes to the slave owner and says, I will give you what would amount to 4 years of salary for a woman of her age to work in a home, which is $200. I will give this to you, you the slave owner, if you will bring the young woman named Lucinda to Ohio where she can work in my home. And he makes it very clear to the slave owner, the moment she gets off the steamboat in Cincinnati, she will be free forever, and she will never, ever have to go back to Kentucky. So effectively what he's doing is buying this young teenager and bringing her to Ohio. He expects her to live in his house. He expects her to spend 3-4 years in his house taking care of his wife, at which point she will be able to go off on her own. She will be 18 or 19, able to start her own life as a free person in Ohio. Now, there's obviously problematic issues here because the young woman, Lucinda, has absolutely no opportunity to say, no, I don't want to do this. She's a slave. But Lucinda is probably smart enough to realize that if she can get across that big river, that's freedom. So Lucinda goes to work for Mclean, and she is immediately a free person. The relationship does not work out very well. It turns out Mclean's wife doesn't like Lucinda. It's not clear if Lucinda likes working. And so Lucinda simply walks away. She leaves Mclean's house and she walks away, goes a 1.5 miles down the road. There are two people here, Kathleen and Ken Stachowski, who are from Springboro, who came to hear this talk. All of what I have just described about Lucinda going away, I would not know because without them helping me, because they're connected to the Springboro Historical Society, which is where Mclean lived. So when Mclean is trying to become president in the 1850s, a radical abolitionist accuses Mclean of being a slave owner. And he says he bought Lucinda, brought her here as a slave, mistreated her, locked her up, beat her, and she ran away. And of course, my friends from Springboro pointed out that, yeah, she walked about 1.5 miles. She didn't exactly run away. She's not running away from Mclean. She's simply saying, I am leaving your employment and I have a right to do it because I'm free. And Mclean does not try to bring her back. Mclean has no legal claim to bring her back. She goes and lives on her own. By the way, Lucinda, a couple of years later, is married to a free black man whose father had been a slave in Virginia, I'm sorry, in South Carolina, and who's the owner of the man's father had taken the father to Ohio and manumitted him, so he is free in Ohio. She marries him, and in 1862, her son will serve in a regiment of the United States colored troops in the Civil War, fighting to end slavery for everybody. So Lucinda will not only get to be a free person and live her life as a free person, but her son will serve in the 127th Ohio Infantry Regiment, which later becomes the 5th United States Colored Troops Regiment in the war. So this is the story of John Mclean. He's a man who hates slavery, but enforces the Fugitive Slave Law when he has no choice. He is a man who has slaves working in his house in Washington because there's really no other option. But then he arranges to have those people come to Ohio as free people. I think it's a great legacy. It's a great legacy for Cincinnati because ultimately Mclean leaves Springboro and moves to Cincinnati, where he remarries when his wife dies after a couple of years after the Lucinda incident. And he marries the niece of Salmon P. Chase. So you have the two Ohio justices, the two icons of anti-slavery. Chase is more radical than Mclean. In fact, there are times when Chase really hates Mclean because Mclean rules in favor of the Fugitive Slave Law. Mclean's position is, I have no choice. I took an oath to support the Constitution, and that's what Supreme Court justices are supposed to do. I would argue that we need more Mcleans on the Supreme Court today. Thank you very much. Questions, comments?
We have a microphone, so if you're asking a question, please speak into
There's
that
one up
because
there.
It's being recorded.
Talk a little bit about whether Mclean was involved in overturning the Ohio Black Laws?
Okay, so the Ohio Black Laws are a really interesting issue. First of all, the Constitutional Convention of 1803 writes a constitution that is emphatically anti-slavery and then says that only white men can vote. However, there's then a debate about who can hold public office. And this is the weirdest thing I know about race and state law in the period. Ohio Constitution does not say that only white men can hold public office because the Constitutional Convention says that in a democracy, the people have a right to vote for whoever they want. And in 1858, John Mercer Langston, who is a graduate of Oberlin College and one of the few black lawyers in Ohio, is elected to be the county attorney in Lorain County. So you have this weird state, which on one hand says, Mr. Langston, you can't vote for yourself, but you can be elected to be the county attorney in Lorain County. And John Mercer Langston's nephew will be the great poet Langston Hughes. So that's one piece. The Black Laws say that, which the first legislature passes, say that if a African American moves to Ohio, that person must prove that she or he is free, and that person must find a surety to sign a surety bond saying that if that person becomes impecunious and poor and goes on what would count for welfare, the surety will pay the state $500 for the person's upkeep. There are some people who sign surety bonds. There are a lot of people who come to Ohio who do not get surety bonds. The black population in Ohio in this period from 1803 until 1850 grows to the point where by 1850, Ohio has the third largest free black population of any state in the North, only surpassed by Pennsylvania and New York. So the Black Laws are, in that sense, are mostly ignored. But the really interesting thing happens in 1848. 1848, you have a three-party presidential election. You have the Whigs running the Mexican war hero, Zachary Taylor, who, by the way, owns a huge plantation in Louisiana. You have the Democrats, who are running a traditional, in those days, the Democrats are the party of the South, the party of slavery. It's a country where racism is everywhere, but the Democrats lead the way because most of the Democratic candidates are slave owners. So you have the Democrats running, and then you have something called the Free Soil Party. And like it says, Free Soil Party means they are against allowing slavery in any of the new territories acquired from Mexico. In the Ohio legislature in 1848, neither the Democrats nor the Whigs have a majority of the legislature. There are 6 members of the legislature who are Free Soilers. And in a very close legislature, they have the balance of power. They go to the Whigs and they say, we will organize with the Whigs. We'll vote with the Whigs because you guys are more anti-slavery. We'll vote with you. We only ask for a couple of things. Repeal the black laws, provide public schools for black children, and send to the Senate, because in those days, the legislature elects the Senate, send to the Senate the abolitionist Whig congressman from the Youngstown area, Joshua Giddings. And the Whigs, showing monumental stupidity by a political party, says, we would never elect Giddings to anything. We hate him. He's a troublemaker. So the Free Soilers go to the Democrats and they say, we will vote with the Democrats and you can organize the legislature. We have only 4 demands. 1 is you repeal the black laws. 2, you have black education. 3, you make sure that this one judge who is really racist and really pro-slavery gets fired as a judge. And 4, you send Salmon P. Chase to the Senate, the Attorney General for fugitive slaves. Democrats say, fine, we want power. We have no ideological views. And somebody writes a comment about how weird it is to see this one racist Democrat after another standing up and voting to repeal the black laws. Mclean is on the Supreme Court then, so he's not really involved in the politics of this. But it's worth understanding what happened. Do we have time for another question, or we
can take one more quick one, I think. Go ahead.
I guess we don't need time for another question. Thank you very much. I hope this was helpful.